On October the 18th, 2019 in the afternoon, Kelly Keese was shot and killed by Justin Cheney in our jurisdiction. That occasioned an investigation, followed by an arrest, and a case that is set for later this morning at 8:30 for the filing of charges. And I'm here to announce on behalf of the office that we will not be filing charges at this time on that shooting death. Now, the investigation took a while to complete. There was significant analysis on the applicable law involved. And the bottom line is, before I turn it over to Chief Deputy District Attorney Gary Dawson, is that this was an incredibly imperfect situation with a million other alternative outcomes. But this one, under the laws that we have in the state of Colorado, is one that I did not feel we could rightfully and successfully prosecute.
Can you tell us how things transpired and what was it that led you to that decision?
Yeah, I'll leave some more of the details to Gary, but in essence, there was a dispute that occurred inside of an apartment building where an individual named Andrew, is it Bernadou? Gary? How do you pronounce the last name? On Bernadou? There it is.
Take it again.
Yeah. There was a dispute, a verbal dispute that took place inside an apartment building in Lone Tree between Justin Cheney and Andrew Bernadou. It ended up becoming physical, with Mr. Bernadou unprovoked striking Mr. Cheney in the face. Mr. Cheney responded by brandishing a concealed firearm that he had a permit for. During that confrontation, and by the way, this whole time, Mr. Cheney's girlfriend had called the police, and the police were en route. Mr. Bernadou's girlfriend, Miss Keese, came to the door. She retrieved her own firearm, came and threatened Mr. Cheney with it. Mr. Cheney ultimately fired a single round that went through Miss Cheney's neck and other parts of her body, killing her. And then the police arrived and took over the investigation from that point right there. At the end of the day, listen, I mean, the questions that have to be asked are, was this inevitable? It was not. Were there other alternative decisions that everybody associated with this case could have made that would have resulted in no bullets being fired and no lives being lost? Absolutely. But at the end of the day, we are left with the laws that we have on our books, and an analysis of these facts, this investigation, and those laws resulted in us concluding, and the Douglas County Sheriff's Office concluding, that this was not a prosecutable case at this time.
You keep mentioning at this time. Is there a chance, and you also mentioned the investigation is complete, so what is the likelihood, or is there a chance that you might file charges at a later date, or that you are continuing to investigate this?
Yeah, I don't want to go, Dumb and Dumber and say, so there's a chance, 1 in a million. I think it's unlikely, but to the extent that there is additional witness that ever becomes known to us that we don't have right now, and off the top of my head, I can't contemplate what that is. Remember that the statute of limitations for murder is forever. So the fact that we choose not to file charges at this time does not close the door for eternity on this. But I do think it's unlikely that we'll come up with additional evidence that would change this outcome.
How many similar cases have you seen in terms of is this a stand your ground type of situation, or a self-defense situations that are comparable to this that you've elected not to pursue?
Yeah, sorry. I'm not going to look at you when I answer. Is that all right? Colorado, as you know, is not a stand your ground state. We have a different traditional self-defense statute that's spelled out in the letter that Chief Deputy District Attorney Gary Dawson generated for us on this case. We don't see cases like this very often. In some murder cases, we do see the defense at trial raised of self-defense. It is rarely successfully raised. Now, recently, we have had a case in this jurisdiction where a father shot and killed his son inside of his home. And the court determined, after a pretty vigorously fought hearing, that that was an act of self-defense, and that precluded further prosecution of that case. But this is rare.
Have you talked to the victim's family?
I personally have not spoken to the victim's family. I know that our office has been in contact, and I presume Chief Deputy Gary Dawson will be able to talk to that too.
I guess what would your message be, though, to the family if you were to talk to them?
I'm so sorry. What do you tell someone whose daughter was shot and killed? And I'm here to tell you that having looked at what I have in this case, I don't know that she did anything wrong, and yet here we are. I don't think she broke any laws, and yet here we are. I don't think she was wrong in pointing a weapon at Justin Chaney when she came to the door and saw that he had her boyfriend at gunpoint. I don't think she deserved to be shot and killed. That's not the analysis. That's not where this case ends. Where this case ends is with an analysis of self-defense law and whether or not under the circumstances self-defense applies. And then beyond that, whether or not we have a reasonable likelihood of success at trial given the facts and the law that we have. And the conclusion from everybody on this side that has looked at this case, when I say this side, I mean the DAs and the Douglas County Sheriff's Office, was no, we don't.
Should we talk to him?
Yeah. He'll have all the facts and stuff. Can I D-mic or whatever?
you go.
There's a term for that, isn't there?
Probably.
Dude, did you come out from Albert this morning? How was Albert?
Albert wasn't bad. I came, of course, at 2 in the morning because I work the morning show.
What is wrong with that job?
Yeah.
That's why they're paying you $400,000.
But you get up at 4:30 and tune in, don't you?
Sometimes I tweet.
Yeah. Actually, I did see a tweet from you.
Sorry about this.
You got it all.
I would appreciate
Coat
it.
pocket?
Thank you.
Yeah. Put it in there. That's the best bet. You always ask that after you
I do.
I'm gonna run to the office and I'll meet you down in A.
Okay. I just got one more here. We'll just clip it there. There you go.
Okay, I gotta do one more too.
All right.
Good to see you. We met once before I started rocking out. Yes.
Oh, okay.
Can I do it under there?
Yeah, sure.
All right, thank you.
I can't remember.
All right. Yeah. Tell us are you guys ready?
Yep, ready.
First and last.
First and last, Gary Dawson, D-A-W-S-O-N, like Dawson's Creek.
And you are the,
I'm a Chief Deputy District Attorney.
what do we got?
What do you want to know?
Okay.
Go ahead. I mean, I guess, what are the details? He said you have more details about what happened. I guess, what is it that about this case? What was the original altercation that, why were they fighting?
What did your office find in this?
Okay, so Mr. Chaney believed that Mr. Bernardo had been trespassed from the building. We did not actually find out that that was correct information, but he was under the impression that he was not allowed to be there. So on this occasion, Mr. Bernardo basically forced his way past Mr. Chaney into the building. There was some words exchanged, some profanities, and then Mr. Chaney asked his girlfriend to call 911. She did so. That got Mr. Bernardo more upset, at which point Mr. Bernardo struck Mr. Chaney in the face. It's at this point that Mr. Chaney draws his weapon and orders Mr. Bernardo to remain where he is and wait for police to arrive. It's at this point that Ms. Keiss comes out of her apartment. It's unclear if she was in the hallway and saw the strike or not, or the punch, but she goes back in and gets the weapon and pulls it out and points it at Mr. Chaney. There's a little disparity as to what is said in those 7 seconds, but what is clear is that she is pointing the gun at his face. He says he was afraid for his life, and at that point, when he had the opportunity, he turned and fired on Ms. Keiss. There was one shot fired. We found one casing on the scene. Ms. Keiss fell to the ground and she succumbed to her injuries at the scene.
Mr. Dawson, if you guys don't consider this to be a crime, how would you characterize the situation?
Well, to be clear, it's a crime, but he has in essence, we've determined a complete defense to that crime. Ms. Keiss had the absolute right to pull the gun in self-defense of her boyfriend, as in our analysis, but Mr. Chaney also, unfortunately, had the right to turn and fire on her when he had a gun pointed in his face.
Can you clarify just what the relationship was? Had they had any past history on any sort of altercation, or did they even know each other well?
individuals were neighbors. They were literally one door down from each other. The Cheneys had called the police, and this was verified through call records on at least a couple of occasions on what they believed to be domestic disturbances between Mr. Bernadotte and Ms. Keiss. They also documented some times that they had heard what they believed to be domestic disturbances and had not called the police for various reasons. Mr. Bernadotte was aware of the fact that the police had been called by Mr. Cheney and Ms. Anderson, so they did know each other that way. They did not know each other on any friendlier level.
But he suspected him of trespassing, but he knew that they were neighbors?
Ms. Keiss was the person on the lease. Mr. Bernadotte was not on the lease, and both Ms. Anderson and Mr. Cheney indicated that they had been told by the leasing office that he wasn't supposed to be there. It may have been a misinterpretation on their part about whether he had been actually trespassed, but both of them were consistent that they were under the belief that he was not supposed to be there. He was not, in fact, on the lease, and that gets into a whole...
But you can visit apartments if you're not on the lease.
Correct.
Considering the previous disturbance calls, would you say that that is a history that contributed to what happened in this situation?
I think undeniably on some level it contributed, just because Mr. Cheney was aware of that, and he would have been aware of the fact that there had been some form of what he at least suspected was violence between the two of them. So that would have put him a little more on edge than perhaps a normal, regular, neighborly relationship.
If self-defense is rarely successful as a defense in court, as the district attorney was saying, how come you guys elected not to pursue charges?
Every case is extremely fact-specific, and it's really comparing apples to oranges in every individual case. There are just small details in every case that can change our decision as to whether we think we'd be successful at trial. In this case, one of the things that was somewhat unique was that both the victim's boyfriend, Mr. Bernadotte, Mr. Cheney, and his girlfriend, Ms. Anderson, were all extremely consistent as to what led up to those facts. So in our analysis of was there self-defense, do we have an opportunity to rebut that or disprove that in some way, was really non-existent in this case because they were so consistent about the facts. Even Mr. Bernadotte, the victim's boyfriend, was very consistent about the fact that Ms. Keiss had put the gun directly into Mr. Cheney's face. So again, that's what we're left with, is the question of would a reasonable person feel fear if they have a gun pointed in their face? We determined that was not something that we'd be able to overcome at trial.
So in other words, do you feel that if you would have went forward with the trial, it would have been a waste of time?
Talk about your ethical obligation.
Well, talking about that, one of the things that we analyze in every case is what is the reasonable likelihood of success at trial. We have ethical obligations to analyze that. There's also a further step that we take to determine just personally, individually as attorneys, do we believe that we can prove this case? But to answer your question, it seemed like there was basically no probability of us winning that case at trial. There was also the sense of when you see that as a district attorney, when someone seems to be exercising a legitimate right of self-defense, we also have the obligation of recognizing that and not prosecuting someone when we think they're legitimately exercising that right.
Did you consider other charges such as criminal negligence or discharge of a firearm, things that were of lesser nature?
We did, and one of the first things we did to analyze that was whether or not when he first pulled the gun, whether that was lawful when Mr. Cheney pulled the gun on Mr. Bernadotte, and we determined that because he'd been struck in the face, that was an assault in his presence, and he had the right to self-defense himself, as well as the right in Colorado to perform basically a citizen's arrest. So once he had lawfully pulled that gun, things kind of naturally flowed from there.
And his appearance today?
He'll be down in Division A at 8:30 this morning to receive essentially the notification that we are not going forward on the charges.
Which is
Yeah. Do you want me to mention Bernadotte?
yes, please.
Okay. There's one other aspect. In reviewing the charges against Mr. Cheney and declining charges, Mr. Bernadotte was also charged with the assault on Mr. Cheney that precipitated all of this, and our office has reviewed that and determined that we will not be proceeding on those assault charges by Mr. Bernadotte against the person who shot his girlfriend in the face.